and my esteemed sister, Justice Bila Trivedi, and while upholding the validity of the impugned amendment, I have thought fit to observe, I quote, thus, reservation is not an end, but a means to secure social and economic justice. Reservation should not be allowed to become a vested interest. Real solution, however, lies in eliminating the causes that have led to the social, educational, and economic backwardness of the weaker sections of the community. This exercise of eliminating the causes started immediately after the independence, that is almost 7 decades back, and it still continues. The long-standing development and the spread of education have resulted in tapering the gap between the classes to a considerable extent. As larger percentages of backward class members attain acceptable standards of education and employment, they should be removed from the backward categories so that the attention can be paid towards those classes which genuinely need help. In such circumstances, it is very much necessary to take into review the method of identification and the ways of determination of backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant for today's conditions. The idea of Baba Saheb Ambedkar was to bring social harmony by introducing reservation for only 10 years. However, it has continued past 7 decades. Reservation should not continue for an indefinite period of time so as to become a vested interest. In the result, I hold that the impugned amendment is valid and in no manner alters the basic structure of the Constitution. Thank you.
Finally, I invite Justice Savindra Bhatt to place it.
Big update coming in from the Supreme Court of India. 3 judges have batted for the EWS quota for the 103rd Amendment of the Indian Constitution, with 3 out of the 5 judges in favor of the 103rd Amendment of the Indian Constitution. Now it is a thumbs up. EWS quota is good in law. It's not violative of the basic structure of the Indian Constitution and the scheme of the Indian government to give some kind of reservation for economic upliftment of certain communities which were earlier not recognized has been given a go-ahead by the Constitution bench of the Supreme Court. We say this on the basis that 3 judges on the bench, I'm going to read out the names, Justice Dinesh Maheshwari, Justice Bela M. Trivedi and Justice J.B. Pardiwala, have said that EWS quota does not violate the basic structure. This was the moot question. The moot question was that the basic structure is that you give reservation based on social and historical factors, not on the basis of economic factors. The argument of the government was we have the right through our legislative wisdom to create a new category. That is exactly what we have done. And this EWS quota was then challenged in the Supreme Court with about dozens of petitions lined up. The court heard the arguments at length and today has delivered this big judgment. EWS quota is good in law. It is not violative of the basic structure of the Indian Constitution. It does not fall foul of the Indra Sani judgment that prescribes a 50% ceiling.